talking about setting up our estate plan so that our wealth goes where we want it to go. And joining us no pressure, is Adam Sherry. He's an estate and trust attorney with Nancy Spector. The law offices of Nancy Spector, their website is nancyspector.net. So what are some of the reasons why everyone or most people should have an estate plan?
That's a good question. And actually there's a simple and gruesome answer, which may not be a typical fare for your show, but at some point in all of our lives, we're either going to lose the ability to make our own decisions. We refer to that as a loss of capacity, or we are going to lose a finger, Ryan? Is that
marriage?
We're definitely going to we may get married at some point, but another reason why we all need to be thinking about our estate plan is that, of course, we're all going to pass away at some point. And like your guest mentioned earlier, if you fail to take proactive steps to outline what it is you want to happen, who it is that you want to act on your behalf, there's a default set of laws in place, which in this case is governed by the probate code, that will make these decisions for you. So our goal is to work with clients to help them identify who it is that they would trust to make those decisions for them, what it is that they would like to happen to their assets after they pass away. And then, we come in addition to kind of talking through those issues, by preparing the documents that are legally necessary to make sure that their wishes are carried out after they lose capacity or they pass away.
So there's some legal reasons, legal and tax reasons why we set up estates, right?
Yeah.
The first, obviously, is to avoid probate.
Definitely. So probate is kind of like a four-letter word in our industry, and anybody who's experienced it kind of causes their shoulders to tense up. And so probate, very broadly, is the situation in which the court supervises the transfer of assets after somebody's death. So that means that they determine who it goes to based on the probate code or maybe somebody's will, but they also are intimately involved in the transfer of those assets. And so, our concerns, and that may not sound immediately like a problem, but the issue is that we try to help people avoid is that it's really expensive. It ends up costing, a multiple of what it might cost if you took some steps in advance. We're talking 10 times based on attorney's fees. It's really time consuming. It can easily take 6 months to a year, and it's public too. So the records regarding, what it is that you own when you die, some of the details of your family relationships, those are all then part of the court's records, which are available to anybody who has access to the internet.
That's a big that's a big issue with a lot of people.
It really is. And
Yeah.
so trusts function by you're able to take a step during your lifetime in which you create this document which allows you to circumvent the probate process. And so when I say circumvent, I mean that you are transferring ownership of your assets to a trust, and then at the point that you pass away, the assets don't go anywhere. It's just they remain in the trust and somebody else steps in. And because you've already identified who it is that you want to step in and what it is that you want to happen with your assets, it's not necessary for the court to supervise that process. So the upside being then it's no longer a public matter. It's significantly faster. And because you're able to do advanced planning, the associated administrative costs, legal fees, et cetera, are all significantly lower.
We're talking with Adam Sherry, who is an estate and trust attorney with the law offices of Nancy Spector. Their website is nancyspector.net, nancyspector.net. So as we talked about with Alan, once you have your estate plan set up, we have to communicate with you on a regular basis, right? Because, for instance, a tax law change just happened in 2018, and that changed things significantly.
That was a big deal. Yeah, let's talk about that for a minute. So some good news for some of the people who are watching your show is that generally speaking, a lot of people will make an assumption that their estate will be subject to a tax by the government at the point that they pass away. And so one of the nice pieces of information I get to deliver early in a meeting with a client is that that only applies under certain circumstances. Those circumstances, rather, are when your total estate exceeds a limit that's set by the government. And so previously, that limit was about $5.5 million. So long as you were under $5.5 million, you weren't subject to the estate tax. Now, within the last year, that amount has been doubled. So now we're dealing with anybody who has $11 million or less in their estate can count on not having to deal with estate tax when they die. And so that's had a pretty significant impact on some of the ways that some of our clients plan. And it actually has a bigger effect on a lot of our clients who are well under that amount than the ones who are over it. And the reason is that so I just mentioned a threshold, a limit of $5.5 million and now $11 million. Well, since in 2001, let's say, it was as low as $675,000. So it was really standard for attorneys who were preparing documents at that time to structure trusts in a way that would enable the client to limit their exposure to the estate tax. The downside, of course, was that it increased the amount of administrative work that had to happen. Oftentimes, you're dealing with two trusts after the first spouse passes away. So since 2001, based on the increase in this taxable the taxable estate, since it's so much higher now, that secondary trust isn't available, so isn't necessary for tax purposes. So in a lot of cases, we're amending people's trusts to make it easier after the first spouse passes away.
Yes. We're talking with Adam Sherry. He is an estate and trust attorney with the law offices of Nancy Spector. Their website is nancyspector.net, nancyspector.net. So you've set up a lot of estates for clients over the years. What mistakes have you seen people, not with yours?
Of course not,
but with other ones, maybe of people that, or things that they didn't consider when they did an estate plan with someone else.
Yeah, and so to return to the issue that you just raised, so Alan and the people in Alan's office will get in touch with their clients on at least an annual basis. We deal more in a transactional nature, so we would love it if our clients contacted us every year to touch base and let us know what's happening. But generally speaking, that's not part of our model. And that's because, as I said, we establish documents, and then our clients may need to return to them after a life change. So maybe the circumstances have changed regarding their children, a marital change, they may have separated from their spouse. And so one of the biggest problems that I find is when clients make assumptions regarding what is in their estate plan, or they may have forgotten to contact us after there was a major life change. And so they at the point that the document becomes most necessary, it's no longer a good fit for their lifetime. So for their life circumstances. So really the biggest mistakes that I see are when they fail to get in touch with us on every once in a while. I'm talking every couple of years to make sure that everything is what they imagine it is. And then the other big one, and this is one of the areas where Alan and I have been able to work together, is where they don't coordinate their estate planning documents with some of the other documents that exist outside of their estate plan.
We're talking with Adam Sherry. He is a trust and estate attorney with the law offices of Nancy Spector. Their website is nancyspector.com, nancyspector.net.